Yeah, he does that to me too. Good afternoon, everyone. Welcome to the Appellate Division First Department. According to this, there's almost 5 hours of argument time requested. So that would put us at 7 o'clock, right? So that's not happening, okay? So please keep in mind, only ask for the time that you believe that you need in order to bring out the salient points of your arguments. Keep in mind that we have read your briefs. We're fully familiar with your arguments. If we need additional time, we will certainly, take that time. First matter on the calendar, People v. Khalik Artis. You weren't listening. We'll take care of it. 525. Biancoli versus the City of New York. Okay, so what did you say, 6 and 5? What was that? Wow. Okay, so here, 6 and 3, 3 and 1, and 5. You're quite welcome. All of you are quite welcome. Cherry Operating versus CPS V Company. Oh, and we're happy for you to submit. Submitted. People v. Nestor Galindo. 5, 2, and 5. Pacheco versus Alma Realty. Okay. You all have cross claims? All of you, there are cross claims on all of those? Only 2. Yeah, SNS and Alma have cross claims, right? Cross appeals. Okay. So 5 and 2. Alma, you have 5 and 2, 5 and 4. Bovis Lend Lease versus Lower Manhattan. 6, 2, 5. Goldberg versus Schwartzberg. I don't have that. We only have the appeal, so that's all. All we have is the appeal. Okay, respondent? Excuse me, 5, 2, and 3. Salerno versus Shea. Matter submitted, thank you. Tahari versus Narcus. 5, 2, and 5. Martin v. Gecko Corporation. 5, 2, and 5. Justice Oing is recused on that matter. Bin v. Bin, submitted. Sodi versus IAC Interactive Corp., submitted. Dabrowski versus ABAX Incorporated, submitted. First matter is People v. Khalik Artis. Ms. Meese, how are you?
Good to see you, Judge. Good afternoon. May it please the court, Marika Meese for Appellant Khalik Artis. This court should reverse Mr. Artis's gun conviction because Bruin struck down the proper cause requirement of the licensing scheme, and that's inextricably intertwined with New York's criminalization of gun possession.
So I was looking through the record. I could not find, where is it that your client applied for a license?
He did not, Your Honor, and we admit that he did not. But because he was 18 and therefore ineligible to apply under the New York licensing scheme, which sets an age requirement of 21, he did not have to apply in order to have standing in this matter.
So this is Bruin, right?
Right.
It's like almost 200 pages or something, which I've read. I read it last night. I read it last week because we had another case dealing with Bruin. So can you point me to where in Bruin it states that an individual has the right to possess the weapon, that there is a constitutional Second Amendment right to possess a weapon, as in this case?
It doesn't say that, Your Honor, but because they struck down the proper cause requirement of the licensing scheme, and the only way to lawfully possess a gun in New York is to submit to that now unconstitutional requirement, it's inextricably linked to the way that New York criminalizes gun possession.
See, that's what I'm not understanding with this argument, is how does the fact that Bruin struck down the licensing scheme in New York, which required that there be some showing of,
Proper cause.
Proper cause. How does that now give rise to an overall right to gun possession?
It's not that it's an overall right. It's that the only way to possess a gun in New York is through that licensing scheme. And New York only criminalizes unlicensed possession.
Look, the only thing the U.S. I'm sorry to cut you off, but the only thing the U.S. Supreme Court did was knock out the proper cause requirement of the licensing scheme, correct?
Agreed.
It didn't touch the age requirement that you had to be 21 to apply for a license, correct?
Correct.
That's still intact, right?
That is.
So that my next question is that if your client reaches 21, anybody who reaches 21 minimum age can apply for the license. So that here he never had a chance to apply because he was underage, and the Supreme Court didn't strike that. So what's the issue here?
I think Your Honor might be addressing two issues. One is the standing requirement, which normally he would have to apply for a license and have been denied in order to have standing to challenge the constitutionality.
Right.
Because his age did not permit him to, he's exempted from that requirement, because under any circumstance he would have been denied. And we rely on the Second Circuit case Bach for that, because in that case, similarly, an out-of-state plaintiff who had been in Florida couldn't subject himself to a New York law where he knew he wouldn't be able to get a license because he wasn't a resident. Separate and apart from that, the other requirements in the statute, even if they pass constitutional muster, which we argue that they do not, that doesn't mean that the proper cause requirement, which was mandatory and is now unconstitutional, can just be excised from the statute and it's otherwise valid. Because the only way to have possessed a gun legally at the time that Mr. Artis was prosecuted was through an unconstitutional requirement. So they're related in a way such that—
Bruin didn't take away the requirement that you still be licensed.
No, it didn't. And they said that there could be restrictions imposed. There are other portions of the New York statute that are still being challenged for their constitutionality, including the age requirement and the law-abiding citizen and the other components that the respondent urges would also make
See, the age requirement is still there. It's still intact. So that so he could have applied and he would have been denied the application because he was underage. And as far as Bruin's concerned, that's okay still. That's not unconstitutional. And
But I don't think you can just excise out that proper cause requirement and say the rest of the statute stands. And it also—
Well, it stands because I don't read Bruin as so expansive as my colleague says that it knocks out. I mean, it's just limited, saying you can't. The proper cause requirement is gone. That's it.
But anyone who wanted to lawfully possess a gun had to meet that proper cause requirement, and that the Supreme Court has found conflicts with a person's
Well, he couldn't
Second
even
Amendment
meet
right.
that because he was underage. He didn't even past the first threshold. You got to be at
Right,
least 21.
There were at least two factors. One was the age, which he didn't meet, and the second was the proper cause. So they excised. They said, okay, you can't have a proper cause standard or what have you, but they said nothing about the age requirement.
Well, but in order for the age requirement to pass constitutional muster under Bruin, they have to show that there's been a historical tradition of disarming people of that age.
But Bruin Bruin, I've read it. I've now read it 4 times, okay? Bruin does not talk about that. I don't understand how you give such an expansive reading to Bruin. And not to mention that in this particular case, it's not a straight possession. It's not as if your client was walking down the street and he was stopped and he was found to be in possession of the weapon. He fired the weapon. The allegation and what he pled guilty to was the CPW-2.
He was never alleged to have fired a weapon. There were 4 people
But
in the car.
he pled guilty to CPW-2, right?
He did, correct, Your Honor.
With intent to use unlawfully?
No, just a straight possession, not in the home or place of business. Under the car presumption, there was a car stop with 4 people in the car, and the other 3 co-defendants were over 21. So if a single one of them had had a license, he too would have been exempt from prosecution. So I think that is how the age requirement also impacts his case.
Why would he have been exempt from prosecution if someone had a license?
Because the car presumption and the statutes say that if anyone is licensed, then the car presumption doesn't apply, and that was the theory under which the prosecution brought the case against him.
So even if the gun were on his person, because another individual in the vehicle had a license, he could not be prosecuted?
They might have then been able to show his actual possession, but since they prosecuted under the car presumption, I believe that that statute applies, and that therefore, if any of them were licensed, then the other 3 were over 21. So I think that satisfies the age concern. But I don't think that you can just excise that out, the proper cause, and say that the other provisions stand.
Thank you.
Good afternoon, and may it please the court, Catherine Murata for the people.
So do we read Bruin to also state that the age requirement or an age requirement would also be unconstitutional?
No, Bruin was narrow in scope. It only struck down as unconstitutional the provision, the proper cause requirement. It left the age requirement undisturbed. Here, defendant was 18 years old at the time of the offense. So the age requirement is a valid basis upon which his theoretical license application would have been denied. Here, as an initial matter, defendant's Bruin claim is unpreserved. He lacks standing as well to bring the claim. The record.
Well, he lacks standing because he never applied.
Correct, Your Honor.
Right? But he couldn't apply because of the age requirement.
Right. Although the record is, in conjunction with the standing, the record is so undeveloped that it's unclear if his license application would have been denied on the proper cause requirement, on the age requirement, or several other grounds that Bruin left undisturbed.
And in terms of the preservation, I mean, this occurred prior to Bruin. Is that correct?
Correct. He pled guilty and sentenced in 2019. Bruin was decided in 2022. However, he failed to bring any of these claims in the lower court, and there is no futility exception to the preservation requirement.
I guess it would be a different analysis if the individual was over 21 when he got convicted or pleaded guilty. In this case, anyone under 21, I mean, the basis is that they're just convicted or plead guilty to a criminal possession, and that's, as far as I read Bruin, that's not unconstitutional. That's not an unconstitutional, that doesn't require setting aside that conviction.
Correct, Your Honor. The age requirement was not struck down. It was only the proper cause requirement.
Yeah, they're trying to bootstrap the proper cause requirement into an analysis to say that, oh, you know, the age requirements should also be struck down as unconstitutional.
Right. The defense is trying to broaden the scope of Bruin where it's really just limited to the proper cause requirement. And defendant references the showing historical tradition for the age requirement.
Well, yeah, that's what I was going to say. It's more than simply, an attempt to bootstrap. I guess there's also the argument that there has to be a basis shown. I think that's what Bruin does talk about. There has to be a basis shown for the requirements.
Correct. When a provision or licensing restriction is challenged, we would have to show a historical tradition for that restriction. But here, there's ample support for restricting 18 to 20-year-olds from the right to bear arms. I cite several cases in the brief. Just like the main takeaway is that historically, until the 1970s, people under 21 were considered minors. And looking at Bruin says to refer to the founding era and Reconstruction era statutes to analyze this historical tradition. And there are several cases that I cite in the brief, Bondi, NRA versus ATF, where it shows that there has been a historical tradition of restricting the right to bear arms for 18 to 20-year-olds. And here.
And that restriction in terms of 18-year-olds, it's for law enforcement as well. Is that correct? A police officer, can you be a police officer or a law enforcement officer at 18 and carry a weapon?
That I am not sure. I know there is a provision in Penal Law 400 where there are certain occupations where the age requirement or certain requirements don't apply. I'm not entirely sure. But also, just as relatedly, the defendant cites that that the right to bear arms is coextensive with the founding for 18 to 20-year-olds to be in the militia, but that's not coextensive, and there is a historical support for denying 18 to 21-year-olds the right to bear arms.
Well, they can serve in the military at 18, right?
Correct. That's what defendant cites in her brief, but in the cases that I cite, those decisions hold that the right to serve in the militia is not coextensive with the right to bear arms. So taking all those factors into account and all the procedural bars, there's 4 independent procedural bars in which to deny this this claim. I ask that you affirm.
Thank you.
Thank you.
In terms of the historical tradition for the age restriction, the cases respondent relies on deal with gun purchase and are different. And they also deal with the wrong time period that Bruin identified, the founding, and they deal with sort of post-Reconstruction. So I don't think the prosecution made their burden in terms of establishing a historical tradition that would permit an age restriction, as they identified in their brief. And I'd just like to turn very briefly to the youthful offender issue. This court should adjudicate Mr. Artis a youthful offender for 2 reasons. First, there is statutory mitigation for the armed felony offense here based on his age, him not being the sole participant, and being comparatively minor role as to the
Also,
other
he has 2
older.
prior youthful offender adjudications for gun charges. He had a separate firearm case pending at the time, and he was photographed with the recovered firearm.
Those facts are.
That doesn't sound to me like something that would lend itself to youthful offender finding.
Those facts are all true, but it doesn't preclude youthful offender. This court and other courts have
It's
granted.
not about preclusion, it's about whether he's merited it.
But here also, the second ground is that there was a resentencing, and that was after Mr. Artis has served the entire 3.5-year sentence. And during that time, he demonstrated remarkable rehabilitation. He didn't have a single ticket or disciplinary infraction. He did every available programming. He was able to do the IPA program, which is a very coveted program that very few inmates are able to do. And he had remarkable family support and chances for rehabilitation. So given
But
that.
didn't the court didn't the court state that they understood all of this but still that they did not believe that youthful offender status was appropriate?
The court did so, but this court, of course, is free to reach its own determination and need not defer to the lower court. And I'm saying that although the circumstances of the prior gun possession may have been problematic, the fact that he demonstrated remarkable growth and rehabilitation, and the fact that it was 3 years later, it does warrant youthful offender to prevent him from having a violent felony that will forever stay with him and impact his ability to reintegrate into society.
Thank you.
Thank you.
Both. Biancoli versus the City of New York.
Good afternoon.
Good afternoon.
May it please the court, James M. Catterson, Pillsbury, Winthrop, Shaw, Pittman, on behalf of Appellant Emblem. In what I can only characterize in it as a rather extraordinary departure from precedent, Supreme Court abused its discretion by issuing a mandatory injunction, upending the status quo based on nothing more than the
Why is it a mandatory injunction? Why is it not a prohibitory injunction? Since it prohibits them from collecting a payment, it doesn't force them to do anything.
Well, Judge, that would, I suppose, have been true had they moved for an injunction the day after the co-pays were instituted, or the announcement for the
But
co-pays.
it's not seeking to get money back that's already been paid. It's only seeking the preliminary injunction to stop the payment from going forward. Isn't that correct?
Judge, I'll quote this court back to itself. It's second on second. It's a David Friedman opinion, a marvelous magnum opus on mandatory injunctions. And the court said, a mandatory injunction, parens one mandating specific conduct by which the movement would receive some form of the ultimate relief sought as a final judgment, is granted only in unusual situations where the granting of the relief is essential to maintain the status quo. Here, at the time the injunction issued, 11 months after the imposition of co-pays, what Emblem had to do was rewrite all the software. They had to inform every single provider and every single one of 183,000 retirees that they were no longer imposing co-pays. Emblem was ordered to do this all immediately. They weren't prohibited from collecting the co-pays. They were told to unwind the co-pay program that the MCL agreed to with the unions on behalf of the city.
Counsel, let me ask you a different question.
Yes, Judge.
What in the contract, in your view, is the benefit that the plaintiffs are claiming as their benefit that they should get? Am I reading the contract correctly? GHI or Emblem gets paid $100 cents on the dollar, correct? Either from the city initially or then after a true-up. So what is it that is your understanding is, how are the plaintiffs third-party beneficiaries?
They're not.
Well, that was going to be the question. I think that was the threshold question, was whether they are in fact third-party beneficiaries.
They're not.
And why are they not third-party beneficiaries?
We know that, Judge, because of two things. The contract, which they talk about extensively in the complaint, is the contract between Emblem and the city for Emblem to administer the plan. What the court quoted extensively in the decision wasn't the contract between Emblem and the city.
But why isn't the certificate of insurance part of the contract?
Well, Judge, I'm glad you asked me that question. Rarely am I glad to be stuck with a contract question. But the certificate of insurance specifically says, and I'm going to quote it, it is not a contract between you and GHI. So far from being an intended third-party beneficiary, which is the standard they would have to satisfy, the certificate of insurance says specifically it's not a contract with the enrollees. It's not. And the underlying...
I'm not following you. Why, if it's not a contract, does that stop them from having third-party beneficiary status?
They can only have third-party beneficiary status if they are intended third-party beneficiaries of a contract. There is no evidence of record that they are third-party beneficiaries of the contract between Emblem as the administrator of the healthcare program and the city of New York.
Does Emblem have some right itself to the $15?
No, Judge.
So, right, that's what I'm trying to figure out.
Oh.
What is it? What is it that this is a contract, this is how we're going to administer the plan, right? At the end of the day, there's no right from Emblem to get the $15.
Emblem only, it's in the complaint. I'm not, this isn't theoretical on my part, it's in the complaint. The complaint details how the city entered into negotiations and the city imposed the $15 copay to save money on health care costs.
But where in the contract between the city and Emblem does the city have the right to impose requirement, which it did not previously, for Emblem to collect a $15 copay for the city?
Okay, that's a different question, and I
Well,
would...
if we're taking that they're third-party beneficiaries, they can make that claim that there is no such right and they're third-party beneficiaries of that inability to impose a copay.
If that were the claim, it's not, but if that were the claim, then it would be barred by the 4-month statute of limitations under Article 7.
Not if it's a third-party, I'm going to let you answer the question, but not if it's a third-party beneficiary breach of contract claim, because then it's not an Article 78 claim. It's a breach of contract claim being asserted as a third-party beneficiary.
But on the record in front of this court, the contract that the court was referring to in its decision, the contract, and I use that guardedly, the contract that the court quotes is the certificate of insurance. It's not the agreement between Emblem and the city. Nowhere in there does the court ever refer to that. And
So can I just ask you one more question, which is, why are you, isn't there a First Department case that says you can't collect these premiums? Isn't there a First
no,
Department?
it's Campion. You're right.
Right.
You're part right, Judge. It's Campion, and it's 2022.
Right.
That's not a premium case. Campion was a ruling from this court affirming the New York City Administrative Code, Section 12-126, which says that you can't impose premium costs on anybody. You can't impose premium costs on either the city workers or the retirees. There is no discussion whatsoever about copays.
Well, isn't this $15 a premium cost?
No, Judge, absolutely not. And if I could just finish this out, the biggest, I want to say canard, but I don't want to insult the judge too much. The biggest misstatement in this record is that mythical 80-20 discussion. The judge says it's simple arithmetic. It's 80-20. It's free health care. That's just not true. If you look at the record, which the court declined to do, 132, 133, 138, 139, 160, 161, you will find an enormous amount of copays in this plan. So the theory that the city, not Emblem, the theory that the city could not impose copays is utterly false.
So Campion does not state that the city cannot pass along any costs to the retirees?
It does not, Judge. And if it did, by the way, this entire record would go right out the window.
Okay. Let me just ask you
Yes,
one
Judge.
more question, which is, we're talking about the three-prong test, right? And you're saying, well, they don't meet the number one, but number two and number three, they do meet. I'm not going to assume that I think they meet it. I assume that that's correct. Then the number one doesn't, if 2 and 3, like irreparable harm and balancing of the equities, are strong, much stronger in their favor, so what? And you're talking about 11 months of collecting copays with a backup of 20 years of not doing it. So when we're talking about the status quo, in a case where 2 and 3 are really high and 1 might not be quite as high, I don't see where the abuse of discretion is.
Judge, I cannot for 1 second believe that this court will issue a decision that status quo doesn't mean status quo. That phrase has been around, and I know you will appreciate this, since the 5th century in the writings of St. Augustine. It became popular in 1602, and from 1602 forward, and by the way, that was in a marvelous volume of law where a Roman Catholic priest got his head chopped off for heresy. I don't know what he wrote about status quo that made that happen, but the reason it's important is because for the last 200 years in this state, status quo has meant only one thing. That is the state of affairs before, not the state of affairs a year ago or 2 years ago or 3 years ago. Every single mandatory injunction case ever issued by this court has focused on the term status quo and what it meant. And for Judge Frank to say status quo meant, well, it meant before they breached the contract is preposterous. There is no case law that would ever support that. And let me just finish with this, and I promise I'll stop. I promise. Irreparable harm. The only record on this case is an unverified complaint, 2 affidavits that the court cited, which the court said were by petitioners, It's not true. The two affidavits are by non-parties.
Oh,
And
no, I
one,
thought they were by petitioners, by individuals who stated that because of the co-pays, they had foregone medical
they
treatment.
don't say that at all, Judge. They do not say that. Every one of them, every single one of them says the same thing, that they went to the doctor. I'll take the unfortunate Mr. Skolnick. I'm not making fun of Mr. Skolnick. It's the easiest math for me to remember. He went to the doctor 90 times in 1 year, paid the $150, paid the $15 copay, and expected to go 10 more times before the year was out. That is a simple mathematical calculation. He's entitled, if he's right, to $1,500 back at the end of the year. It is a mathematical calculation for every single one of them. But this would also be the first case where the court has allowed class-based relief, a finding of irreparable harm based on a non-party, only for 183,000 retirees. Thank you very much, Judge, for letting me go over time.
Good afternoon. May it please the court. Chloe Moon on behalf of the city appellants. Plaintiffs have all but conceded that the only claim Supreme Court found supporting a preliminary injunction here was not based on the city's conduct.
I'm sorry, was not what?
Was not based on the city's conduct. But the preliminary injunction on this fundamentally insufficient record warrants reversals for additional reasons. The court below granted a sweeping preliminary injunction that affected over almost 200,000 retirees based on limited anecdotal
So,
support.
counsel, let me ask you, do you think, what right do you think, because what is the right that the plaintiff, to the $15 that the plaintiff is saying is contained in the GHI city contract?
Yes, Your Honor. So we certainly believe that they are not third-party beneficiaries, as Emblem has suggested. We
I'm sorry,
think
repeat-
are suing.
I'm sorry,
Yes,
could you
Your Honor.
repeat that?
We think that they are suing on behalf of Emblem's obligation to the city, but we also agree with Emblem that they are not third-party
They're
beneficiaries
enrollees.
on the stat.
Where in the contract between the city and Emblem does the city have the right to tell Emblem to start charging a copay, where obviously tradition that's never been done before? Where in the contract or certificate of insurance is that right provided for, to all of a sudden have the city, as opposed to Emblem, start charging a copay that it's never had Emblem collect before?
Yes, Your Honor. 2 quick points. First, to the extent that there was any question about government agency determinations, that portion of this is
I'm asking you
time
a
barred.
contract question. Forget about, an Article 78 would be time barred. Let's start from that premise, and that this is a breach of contract claim, not an Article 78 claim, and that's a third-party beneficiary claim, whether or not people agree that it is a third-party beneficiary claim. But I'm asking you the basic contract claim. Where in the contract between Emblem and the city does the city have the right to start asking Emblem to collect a copay that it's never had Emblem collect before?
Yes, Your Honor. And I think for this question here on a preliminary injunction, even if we're assuming that there is a likelihood of success on the merits, that's simply not enough here where there's irreparable harm.
Where in the contract does it allow the city to ask Emblem to collect a $15 copay?
We think the contract is silent as to whether or not copays can be imposed.
Is there any contractual provision at all about that?
Your Honor, I think for the purpose of this,
No,
Well,
I'm
for the
asking
purposes
you.
of the question, we're trying to figure out where in the contract it would give the city the right to have Emblem collect the $15 copay. Because from what I can see, the contract is silent.
yes,
Or in
absolutely,
the-
Your Honor,
or
and I
the-
would just point you to Emblem's arguments on that matter and turn us back to irreparable harm, which
Or is there anything in the contract that prohibits the city from saying to Emblem, by the by, collect the $15?
absolutely not. And I think that's what we were saying in terms
Because
of the
that's what
silence
they're
of the
arguing
contract.
is their right, to force Emblem not to collect the $15. And I'm asking you, is there anything in the contract that says GHI can tell the city, I will not collect that $15?
Correct, Your Honor. It's silent as to that.
Wait, but again, it is the city who is directing Emblem to collect the $15. Emblem is not collecting the $15 on its own. They did not decide that they were going to, all of a sudden, that they were going to collect the $15. It was because the city told them to collect the $15.
Fundamentally, this contract is between Emblem and the city, and it's Emblem's responsibility to administer this plan. And so ultimately, that's why this preliminary injunction runs against Emblem. It's because they are responsible for administering the plan and collecting.
Based upon the actions of the city.
Based upon a mutual agreement in this contract between Emblem and the city. They're both parties to this contract.
Okay, so now why then would the plaintiffs not be third-party beneficiaries because they are now being affected by the imposition of the $15 copay?
I think importantly, Your Honor, is that plaintiffs have now conceded that this conduct that the Supreme Court found as grounds for this preliminary injunction is Emblem's conduct. That's essentially the point of this argument.
It's the city's instruction to Emblem, start collecting $15 for us.
That was an agreement between the.
So how did the city, how did the plaintiffs concede this?
In their respondent's brief, they specifically highlighted that their breach of contract claim was directed at Emblem's conduct.
Well, Emblem's the one collecting it at the instruction of the city.
Exactly,
Yeah,
Your Honor.
that's what I'm, okay, thank you.
Okay, thank you so much.
Good afternoon, Your Honors. And may it please the court, Jake Gardner on behalf of the retiree plaintiffs. I'm very excited to be up here right now after what I just heard because I have one word in response to the question about third-party beneficiary status.
They're enrollees, aren't they? They're enrollees.
That's true, and also Plavin.
I'm sorry, what did
And
you just
also
say?
what?
Plavin. Plavin versus Group Health Insurance,
Plavin.
35 NY 3D 1,8. It's a 2020 decision. I'm going to quote the Court of Appeals verbatim here. Hundreds of thousands of city employees and retirees are third-party beneficiaries of this very contract. This is the exact same contract at issue in Plavin. That issue has been decided 2 years ago, so I'm very glad if this.
Well, it
appeal
falls
arrives-
from it falls on the fact that if you're an enrollee, you're a beneficiary. I mean, it just makes logical
Of course,
sense, right?
every insurer and insured has a contractual relationship, and here, the certificate of insurance says you have a right to sue Emblem as long as it's within 2 years of the date that you receive services that you want Emblem to pay for.
But that's in the certificate of insurance, not in the contract, right, between the city and Emblem.
Correct, but the contract
So let
between...
me ask you, what provision of the contract allows you to sue for Emblem's right not to collect the $15?
So to be clear, the contract says that the retirees are entitled to the health care benefits in the certificate of insurance. The contract references the certificate of insurance.
Okay, we can go back, I'm not saying whether or not that's included, if that's incorporated into the contract. I'm asking you, what provision in the contract permits GHI to get the benefit of the $15 that you are seeking now?
So in the certificate of insurance, I'm not sure if this is responsive to your question, the certificate of insurance says that Medicare will pay 80% of your health care benefits of the charge, and Emblem will pay the other 20%. And it's $15 less than that 20% every time they charge a $15 copay. In fact, if you look at the summary program descriptions, which are the annual health care booklet that's published to retirees every year, it says specifically in older booklets from 2004 that the senior care plan does not have copays. And how does it communicate that? It says because Emblem will pay the 20% that Medicare does not cover. That language means that there are going to be no copays. And it's always been understood to mean that for this actually, the senior care contract or the senior care plan goes back farther than 20 years. It goes back many decades, never had copays because the contract forbids it based on that 20% language.
So you're saying that you are basically saying what the city says. Your beef is not with the city, your beef is with Emblem. Emblem has to pay the 20% with its contract with the city. Doesn't the city get reimbursed? Doesn't Emblem get reimbursed for that 20% by the city?
There is a funding arrangement. It's not so simple as just simple reimbursement.
Okay, but they
There's a
get,
premium.
essentially, GHI is not paying any of that at the end of the day.
GHI is paying that if it goes over a certain amount.
And then the city reimburse it. GHI is never out of pocket for your $15.
they are responsible. Again, I'm not sure if this is responsive to your question. Under the contract, it is clear they're responsible for paying the 20% that Medicare does not cover. And it's simple arithmetic that if they charge a $15 copay, that's $15 less than the 20%.
But the bottom line is that the plaintiffs are the ones who are paying the $15 copay.
Correct. Plaintiffs are the ones that pay the $15 copays when under the certificate of insurance, which is part of the contract, they should not be. And for decades, they never had to be.
So that 20% is where you're answering my colleague, is that's where it says you cannot charge the $15. Because
Exactly.
if you do, you're not paying 20% anymore.
And the example is, if there's a $100 service, Medicare has to pay $80, and Emblem has to pay the other $20.
And Emblem never gets reimbursed for that other 20?
The reimbursement is a separate issue. It just so happens that
For you it might be. For me, does Emblem get reimbursed by the city for that 20?
I have to say I don't know all of the inner workings of how the city and Emblem
That's
work
what I'm
out that
trying to
arrangement.
figure out. You're only damaged if they're damaged, right? You're a third-party beneficiary to their rights.
No, Your Honor. We have
obligation.
separate, as third-party beneficiaries, we have the ability to enforce the contract. That is black letter law when it comes to third.
Something is part of your argument, just to understand, I know you're arguing that 80-20 is part of your argument that the certificate of insurance and contract does not provide for any copay to be charged, and therefore it's not allowed under the contract?
No, it's that, well, it definitely does not provide, it does not speak to copays for senior care, whereas it provides for copays for the other plans covered under the certificate of insurance. But our main argument is that it affirmatively prohibits it with the 20% language.
How would it affirmatively prohibit it with the 20% language?
Because here's the example I gave in the brief, here's what I'll give it again. If a service costs $100, Medicare has to pay $80, Emblem is contractually obligated to pay that other $20. When there's a $15 copay, Emblem pays $5, not $20. That is just simple math. It's not disputed. I'll also note that third-party beneficiary status, not argued before, not argued below, so it's been waived. And also, again, I would point this court to Plavin, which just says what I quoted before. And so, because there's just a simple
No,
failure-
it's not that whether or not they're third-party beneficiaries. It's what's the benefit in the contract that the third-party beneficiaries think that they are enforcing, that the right that they have that GHI is not enforcing.
Of course. So that right is the right to be, for Emblem to pay the 20% that Medicare doesn't cover. And by charging $15 copay, that means that Emblem, instead of paying $20 for that $100 service, charges $5. That is just, like I said, simple arithmetic, which is undisputed by the parties.
Could you just address the irreparable harm in terms of the affidavits of the individuals as to the copay and how this affects them?
Certainly, Your Honor. We submitted 9 affidavits, and there were 4 named plaintiffs, individual plaintiffs in the verified complaint that all talked about how they, like tens of thousands of retirees, there are 70,000 retirees who live on pensions of less than...
Were these boilerplate affidavits as suggested by your adversary?
Not at all. Not at all. They're not. I would urge the court to read them. They show the suffering that these retirees who are in their 70s, 80s, and 90s are experiencing. They're living on pensions. 70,000 of them are living on pensions of less than $1,500 a month. Over 100,000 are living on pensions of less than $2,000 a month. They cannot afford the mounting costs of copays. Some of them hundreds of dollars, some of them thousands of dollars. And as a matter of logic, what happens is if they can't pay, they either have to forego needed medical care or they have to do without other basic necessities like medicine, housing, food. And courts have universally held that that is irreparable harm. And I would also point this court to all of the case law we cite on pages 53 to 57. All of them involve situations like this where there's a deprivation of benefits.
Wait, but that's not in the record. You put in the affidavits of a couple of people. You're saying every one of my 1,800 plaintiffs makes $20,000 a year or less. There's nothing in the record as to that. I agree that that is the allegation, and I agree that you put in affidavits from some non-parties now, who may later become class, and some that say, I forego. But I think it's a lot to say that every single one of them is on the poverty line and would never be able to go to the doctor if this $15 copay right?
Well, Your Honor, it's a matter of public record, and it's undisputed. There are tens of thousands of individuals, and it's just common sense. These retirees live on meager, limited fixed incomes. And the case law that we cite that involves this very issue, retiree health care, have all held that that's a permissible inference.
Counsel, how do you respond to your adversary's argument that the status quo is to collect the copay?
Yeah, I will quote another case on page 29 of our brief. North American Soccer League. Here's a direct quote from that case. The status quo in preliminary injunction parlance is really a status quo ante. It always refers to what happened beforehand. Otherwise, you could have exactly what happened here. The party just, on their own, imposes copays, and then the next day says, well, too bad, it's the status quo. You can't unilaterally change the status quo, which they did.
The delay in time here, the 11th-month delay or whatever it was, how does that affect the analysis, if at all?
On statute of limitations, it doesn't affect it at all. There's a 6-year statute of limitations.
No. But what you're saying is the status quo of the day before. But does that mean that we should look back 5 years and say, oh, well, that was what was happening 5 years ago, and I can move now to enjoin what happened 5 years ago and not now? That, I think, is what we're trying to get at. How that's 11 months of something else.
But as a matter of just, you have to draw a line. It's either the status quo the day after or it's not. Otherwise,
Well, that's, I guess, the whole point. A preliminary injunction, right, is something that you move because you need relief right away. So if you wait 11 months for it, isn't the status quo what's been going on the last 11 months and not what happened a year ago?
So the first instance of a copay that didn't necessarily destroy the bank accounts of these individuals, it was the accumulating effect of these copays over months. And I should also note that a lot of them didn't actually get the bills for several months because when they presented their insurance ID card, it didn't say anything about copays. So the doctors didn't send them a bill for months later. So it was after months and months of paying these copays that the pain and suffering really started to be experienced.
Is that in the record?
Excuse me?
Is that in the record? Can you tell me where that is in the record?
It's mentioned in our PI brief. I can't tell you. I can't.
No, I'm talking about factually, right? Where that the reason why you waited a year, basically a year, for a preliminary injunction is because the harmful effects weren't felt. Did anyone state that in their affidavits, or is that stated in the?
I would say that's in all the affidavits, and it's also just a matter, I think, of common sense because.
No, I know you keep saying common sense, but we have to have a record that supports it.
Yeah,
So that's why
I was
I'm
going to say
asking.
common sense, but, was there a showing? We have to make a determination as to whether there was a showing or not.
So, but there is a showing that the copays accrue one service at a time. So the first time you go see a doctor, that $15.
No, I understand that, but the question was why the 11-month delay, and then how do we figure out exactly, when the time began in terms of the status quo? That was the issue.
So the status quo, again, I'll point you to the case law.
No, I understand. We have the answer now. Thank you very much.
Thank you, Your Honors.
It is a difficult rebuttal to make, with all due respect to my adversary, when absolutely, I would say 95% of what he said is not in the record. It's not. It's made up, just like it was made up below. All of you should look at the public record. They're all on limited incomes. I'll tell you exactly what the court said. It's on page 9 of the record. This is what the court wrote. The court believes that there will be, not that there is, will be irreparable harm in this matter. This matter is distinguishable from other cases cited in this action by respondents, by the way, all First Department cases, as the co-payments are being made by retirees, most of whom likely are on fixed incomes and modest means, period. There's no record support of that at all.
Counsel, what's your response to the argument? It's the 80-20. That's where counsel was responding to the question about where in the contract. Where in the contract is it's the 80-20 split that we have here.
The 80-20 argument is a complete and utter fiction. The thought that it is free health care, there is no case that says that. In fact, we cited in our brief, there's a long Southern District case, loath as I am to cite the Southern District to this panel, which goes through the history of health care, provided to municipal workers under 126. And it says there is no such thing as free health care, and there never has been.
So, but let me go, okay, but does GHI have to pay 20% of the retirees' medical costs?
No, Judge, no. If you look at and I urge the court to look at the record. If you look at the record, there are dozens of possible co-pays under the current system, not the new, not the
Those are emblem
quo.
co-pays, those are not city co-pays, right?
I'm sorry, Judge?
They're emblem co-pays, they're not city co-pays.
No, these are all under senior care. All of these plans. What my adversary doesn't want to talk about, which of course the court never mentioned, $50 copay under senior care for emergency room services. Now, they will say, because they said it in their brief, well, that's administered by Blue Cross Blue Shield. That doesn't count.
I just want to say,
same plan.
counsel said that under this contract, GHI is responsible for 20% of the cost of their health care, and if they have to pay $15, GHI has 20% minus $15. Is that what you think the contract says?
No.
Okay, why not?
There is no provision in the contract that's, you must assume that you get free health insurance under the 80-20 rule. You have to accept that as a matter of law, that the contract says it's free health insurance. The contract doesn't say that anywhere.
What is the contract? Is the contract just an administration
Yes,
of
Judge.
this?
And, and periodically what happens is, and it's in their own complaint.
Does GHI have to pay anything under that
No.
contract? Is GHI it gets paid for what it does, right?
Yes, Judge.
Okay. All right.
There is no record supporting any part of their argument. There just isn't. And I feel I'm being strident about it because it is unusual to have to argue a case where there is no record. It's just unusual. Just as unusual as arguing a preliminary injunction for 183,000 people with no class certification. And by the way, they've never moved for class certification, not on the record. So it is very difficult for me to keep saying to all of you, it's not in the record. It's not.
Okay, so the face page of the contract states that Emblem will pay 20% of the reasonable charge as determined by Medicare after Medicare has paid 80% of the reasonable charge. So that's the 80-20
Yes, Judge.
that we're talking about.
That's generically true.
Okay, so now that's where we get the 20%. And so if we translate that to $20, the copay is $15. So now Emblem is only paying $5.
Doesn't work that way, Judge.
I'm sorry?
It doesn't work that way, and I'll give you the example. You go to the emergency room under senior care. Remember, there's only one plan for senior care. There's not two. GHI Emblem administers the primary care physician part of it. Blue Cross Blue Shield administers the entire hospitalization part of it. Under that theory, the 80-20 theory, they could never impose a $50 copay for every emergency room visit. They couldn't, under that theory. They've been imposing the $50 copay forever for hospital services. They just do. And if you look in the record, there are literally, depending upon where you are and how much you're paying out, there are literally dozens of copays.
Counsel, we know that with these Blue Cross Blue Shield and other, just from looking at insurance policy, they all have different categories here. Blue Cross Blue Shield is for hospitalization, whereas the other issues are for, primary care and other office visits.
Judge, what I
Apples
know
and
on
oranges,
this
aren't
record
they?
is there's one senior care plan. It's administered by two different companies, but there is one senior care plan.
I understand there are one senior care plan, but there are multiple layers of insurance. I mean, health insurance just.
So do you agree with your adversary, with the plaintiffs, that under the senior care plan, there was nothing that stated that there was to be a $15 copay?
Not until they all received notice that the city had imposed a $15 copay for primary care physicians. It has nothing to do with any of the other copays. They got a notice a year before. So for my adversary to say, well, they didn't know because sometimes they didn't get the bills for months.
And also their cards apparently didn't state that there was a copay.
Everybody got the notice, everybody. It was published on the website. Not only did they all get the notice, but their lawyer wrote a letter to Justice Frank complaining about the $15 copay immediately. Immediately. That's in the record. We briefed it. So they got the notice.
One second. They wrote a letter to the judge, and then how long after did they move for a preliminary injunction?
The notice went out December 17th of 2021. They wrote the letter on December 19th, 2021. They filed the complaint on November 29th of 2022. They moved for the injunction shortly thereafter. They didn't ask for a TRO originally. Then they refiled it and asked for a TRO. We finally had the argument on January 9th of 2023, and Justice Frank issued his decision on January 11th of 2023. They waited virtually a year.
Thank you.
Thank you very
all.
much, Judge.
People v. Nestor Galindo. Oh, I'm sorry. I forgot. I apologize.
Just 1 minute, Your Honor.
You can take 2.
I just wanted to highlight the irreparable harm here once more. This is a classic example of monetary harms that are not irreparable. And it's widely understood that delay cuts against irreparable harm. And here, as we were just discussing, there was an 11-month delay, almost a year in seeking this preliminary injunction. Coupled with the pleading deficiencies here, relying on a single plaintiff affidavit to try to purport to find that irreparable harm, that's simply not enough. We ask this court to reverse. Thank you so much.
Thank you. No, but thank you. Let's see. People v. Galindo. Oh, my God.
Good afternoon. May it please the court, Ying Ma on behalf of the appellant Nestor Galindo. In a fishing expedition for motive evidence, the search warrant here authorized the police to rummage through any and all data stored on Mr. Galindo's cell phone. It wasn't limited by time, by type of data, or by specific locations on the phone. Respondent claims that this unlimited search was necessary to uncover evidence of Mr. Galindo's hate-filled motive.
I want to address the waiver of appeal first, since you can't get to that issue unless you prove there was not a valid waiver.
Yes, Your Honor. The purported waiver of appeal was invalid in this case. The oral colloquy had multiple critical errors. First, the court told Mr. Galindo point blank that he only had the right to appeal if he took his case to trial, which is patently wrong. The court said, and I quote, it's on page 7 of the plea minutes, if you were to take this case to trial and be convicted by a jury, you could appeal any decision that another judge or I made before or during the trial. But by pleading guilty and waiving your right to appeal, signing the waiver of appeal, you give up those rights.
The court also spoke to the defendant's appellate rights, explicitly stating that they were separate and distinct from the trial rights.
Right, but if the court is directly telling Mr. Galindo that if he took his case to trial, he would have this right to appeal, I don't think you can expect a layperson to then understand that if you didn't take your case to trial, you still had the right to appeal, but that it was being bargained away in this case.
To the extent there was a misstatement, wasn't it cured by the written waiver?
No, the written waiver is not a substitute for the oral colloquy.
Not a substitute, but the Court of Appeals has held that it can stand in the place of a misstatement.
Yes, that is when the court does ask certain questions of the defendant if he understood what was in the written waiver, if he had a chance to discuss them with his attorney, and the court did not ask that in this
Well,
case.
the defendant did say that he signed it and that he didn't have any questions, right?
Well, the court asks him, do you understand and do you have any questions about it? Those two questions directly followed its erroneous explanation. So the court gave this inaccurate explanation. Mr. Galindo heard it, and he understood that, which was erroneous, and he said he didn't have any questions about it. The court didn't.
The court didn't say, do you understand the written waiver, and do you have any questions? He just said, do you understand at the time that he was signing
Isn't it obvious that he was talking about the waiver?
No, the question directly follows what I read out earlier. The court making this explanation. If you took your case to trial, you would have a right to appeal. Do you understand? So Mr. Galindo saying, yes, I understand that. He understood something that was inaccurate.
But the court also went over, Mr. Galindo, as stated by my colleague, the written waiver, and ensured that Mr. Galindo had reviewed it and Mr. Galindo signed it.
He only asked him that, have you signed it? Yes. The court finds this waiver is knowing and voluntary. That's the only question he asks outside of the other two questions, which I submit as part of his erroneous explanation. If I may turn to the merits, Your Honors. In this case, there was not probable cause to search the entirety of Mr. Galindo's phone. There has to be some factual underpinning to the warrant application, some nexus. In other cases, there's, a text message was sent from the phone, a call was made, there was an observation of the defendant using the phone. In this case, there was absolutely nothing. He had the phone in his pocket when he was arrested. The only thing that was in the warrant application was Mr. Galindo's statement to the police. He says, I came to New York City to cut a black girl, but instead I saw a guy I thought was gay and cut him instead. They are arguing that this means that he, made some elaborate plan to come to New York from New Jersey to commit this assault. But as the statement itself reads, it supports that this was not a planned attack. It was a spontaneous sidewalk assault. He may have had a plan to cut a black woman, to target black women, but instead he spontaneously cut someone that he believed was gay. I think it'd be one thing if he said, I made a plan to come to New York to target black people and gay people, but that's not what he said. It was instead a spontaneous attack.
So you're saying that because the animus that he admitted to was against a black female as opposed to a gay person, that's insufficient?
Well, that's the only thing that they point to. That and basically...
Well, isn't it really the planning of an attack for an improper motive, for a hate purpose?
They specifically in their warrant application say that they are seeking motive evidence, not evidence of a plan. And in fact, this...
Well, animus, right? Isn't it? That's what the government has to prove.
Right, they have to prove animus, but they don't even specify, are they proving animus against gay people or animus against black people? I think they are relying on this idea that people...
It has to be that specific?
That's the question.
I think it does, because I think based on the statement, he changed his mind midway. This is someone that does have a documented history of mental illness, but I don't think it supports...
That's another issue in terms of the probable cause for the search warrant, in terms of any history of mental illness. But you have time on rebuttal.
Good afternoon, Your Honors, and may it please the Court, Juliana Susi for the people. As an initial matter, defendant validly waived his right to appeal and therefore foreclosed his suppression claim.
Also, can you tell me, where's the probable cause to search this phone?
The probable cause is from the allegations of defendant's confessions to the police officers that he planned to come to New York City to slash a black girl, and that he cut the victim because he thought he was gay.
How does that implicate the phone?
Because based on the common sense understanding that a phone in which we use for our
common sense again. Everything is common sense. Yeah, I mean, I guess we don't have common sense. I don't understand how him saying to the police, I came to New York, I was going to cut a black female, but then I saw a gay person or person I believe to be gay, so I slashed him instead. I don't understand how now we get to the phone. He doesn't say, I called a friend, or I videotaped it, or I Googled black females in the neighborhood, or neighborhood where you find black females, or neighborhood where you find... I mean, there's no connection that I see to the phone. I just don't get it.
There's no allegation of direct evidence of how the phone was used, but
isn't that like probable cause?
The affidavit has to be read in light of everyday experiences and with common knowledge. And based on how...
So where's the common knowledge?
Based on how everyone uses their phone today as their primary source of communication.
Well, Counsel, let me ask you this. With your argument with regards to the cell phone, would you have probable cause to issue a warrant to search his home or to search a laptop?
I think it would be more reasonable to search the cell phone, Because
Is it about reasonableness or is it about the requirements of particularity?
for the probable cause, it's whether the allegations support a reasonable belief that the evidence may be located
So
in
why not his laptop, right? I mean, because common sense tells us that folks use their laptops or their computers.
He didn't
So why would there not be enough? Why would there not be probable cause to search his laptop?
He didn't have his laptop with
So
him.
is that the distinguishing factor, the fact that he had his phone? So had he not had his phone, are you saying you wouldn't have probable cause to search the phone?
I think it's it would have been reasonable to search the laptop if that was with him, but the fact that he had his phone with him, that goes to
That's an
evidence.
incredible statement. So if he has a laptop, if he has a cell phone, what papers on him, so you're just free to search everything to look for animus.
No, it was necessary to search the cell phone because of the fact that it would provide reasonable cause to believe evidence of the planning to come to New York City.
What makes you think that he used his cell phone at all to plan this crime?
Based on how everybody uses those cell phones
To
today.
plan crimes? I've never used my phone.
I don't know. I don't know if I get a search warrant. You know, when I used to sign search warrants, I don't know if I got a search warrant that said, you know, everyone uses their phone to research certain things, and therefore we should be allowed to, you know, to confiscate defendant's cell phone.
But this crime is a lot different than other crimes in that the people had to show the extra element that it was motivated by a special factor that the defendant.
Right. The fact that the people have a tough burden doesn't mean that you change the probable cause standard, right? If we follow your lead on this, in essence, any person that's charged with a crime in which the government has to prove an animus, or has to prove premeditation, has to prove intent, and they're carrying a cell phone's fair game.
But the evidence of what we're looking for, the personal beliefs and opinions as it relates to homophobia, there's reasonable cause to believe that that evidence would be in the cell phone. Again,
Why?
given the way.
I still don't understand why. I mean, I just don't get it. You're assuming that everyone uses their cell phone and everyone is going to, you know, is it Google something or send a text message to someone concerning their homophobia. And I just don't understand how legally you make that jump, legally, in order to establish probable cause.
And if the court doesn't agree with the lower court's opinion on that, then I think the court has to understand that any possible error from this denial of the motion was harmless. There's no reasonable possibility that defendant pled guilty because of the denial of this motion. It was because of the overwhelming evidence of his guilt and the lenient sentence offered by the people. If there are no further questions, we ask that you affirm. Thank you.
Thank you.
Your Honors, that is not how harmless error analysis works. That is a trial doctrine, and the Court of Appeals has said that rarely, if ever, can a court determine whether denial of a motion to suppress contributed to a decision to plead guilty unless the defendant states his reasoning at the time he takes the plea, and Mr. Galindo certainly did not do that in this case. I just do want to point the court to a decision of this court from 2019, People versus Thompson. I think it directly addresses respondents' argument that, you know, there are just some types of crime that we can assume, we can make certain assumptions to establish probable cause to search. In that case, the defendant sent an indecent proposal by text to an underage girl and called her. That was the nexus for the search. The search warrant authorized a 9-month internet browsing history search and all stored data search. And the DA in Thompson tried to argue similarly that the nature of that crime supported a broad search because, as we all know, people who commit child sex abuse, they have, you know, long-standing proclivities. They have these long-standing habits, habitual conduct. And this court specifically addressed that and said, no, that we can't just rely on those assumptions, even with the general recognition that, I'm quoting, this variety of crime often entails repeated and habitual conduct, including repeated conduct on the internet, but still there were no allegations of child pornography. There was no information specifically indicating the defendant's use of his phone other than to communicate with the victim by text. And here, respondent is trying to rely on exactly the same type of argument that we can just make an assumption because this is a hate crime that people will use their phones to, you know, espouse their hate-filled views. And I don't think that that passes constitutional muster. And we ask that you find the search warrant here overbroad and not supported by probable cause.
Thank you. Thank you both. Pacheco versus Alma Realty.
Good afternoon. We weren't certain about the order, but may it please the court.
There are three appellants, so just.
Right, so it would make most sense for me to go first. May it please the court, David Metzger. I represent the appellants Alma Realty and 3-in-1 Equities. These are the owners of the property, the respective owner and the manager of the building. I'm sure the court is aware of the facts of the case, but just in general, it involves an overnight incident from November 23rd, Thanksgiving night. We had contracted with Syncom Construction, a contracting company, to do a rent.
Why wasn't it foreseeable that this person would end up in the apartment?
For multiple reasons. Well, first of all, the standard is not necessarily what the standard is it foreseeable, not is it possible. The reason that it's not foreseeable is, first of all, the individual who let them into the apartment, Carlos Hernandez, who worked for Syncom, testified that the only reason he was given keys was for the purpose of work. He testified that he was not authorized to and did not believe that he could bring friends after work. This is an overnight, an overnight event.
And in fact, I think he stated that he didn't tell his boss because he was afraid that what his boss would do to him.
Exactly. And the representative for Alma Property, it was his understanding that Syncom, of course, could not let friends or acquaintances or even tenants into the construction area. There was a citation by the respondent, a question and answer, but the first question that was posed to him was, is it your understanding and is it foreseeable that Syncom could let in friends, acquaintances, or tenants into the construction area? And the answer was no. He answered yes afterwards to a compound question, and the second part of that question was, to my point, it can happen. So of course, anything is possible, but it was not foreseeable. And the main reason that it's not foreseeable is because this was a locked apartment. It was an active construction site. It was overnight, Thanksgiving night. There's no water, there's no furniture, there's no bed, there's no stove.
So why is it foreseeable that someone who is without a residence would break in or could possibly break into the apartment? I only say possibly, would break into the apartment, that a trespasser, would go into the apartment.
Well, that's not what happened, and that's a key point, is that there's two things that must be analyzed. More, can it be, is it foreseeable? And even assuming arguendo that somehow this is foreseeable, I don't think there's any other situation where this has ever happened. The court in
There are no other cases where someone who is what we would used to call homeless would break into an apartment or use a basement or something of that nature to sleep in?
Well, behind two sets of locked doors, there's two standards that are required here. First of all, is it foreseeable? Let's assume that it was, even though we're certainly not conceding that. The other issue is the reasonableness of the efforts to secure it. This was a locked apartment. There was two sets of doors. There was locked doors to get into the building. There was a locked door, both keyed, to get into the apartment. All of the cases, and I gladly will go through them, but all the ones cited by us and cited by the respondent cited by the court.
There were no prior incidences of someone breaking in or at least being there unauthorized after hours.
No. And sorry.
Is it correct that the court found that the employee who let the other guy in was acting outside of the scope of his employment?
Right,
correct?
which also goes to another issue.
Right. So why would it be foreseeable that someone would do something outside their
yes,
scope, which obviously got the guy fired, but
right, and
he admitted it was outside the scope of. Nobody told him that he could or would or ought to, and the plaintiff himself said he knew he shouldn't be there.
and not to bring up the common sense standard, but of course they wouldn't.
We have a new
Talking
standard.
about the record.
We have a new standard.
Yes.
We have a common sense
Talking about the record. We don't want any common sense.
I know, but of course, but and also just to your point, Your Honor, though, is Syncom has argued that very point, that this was someone who was acting outside the scope of employment. So in the general case law of respondeat superior, the employer is not vicariously liable if the conduct could not have been reasonably expected. So if the action was not reasonably expected by the employer, then how is it reasonably expected by us? But again, and well, not yet, but the key point that I wanted to make is in every single case, the one cited by the court as well, there was very easy access to the building. There was not the reasonable efforts to secure the location.
The double locks,
They had broken fences, they had no fences, they
Right,
had a
yes.
window to get onto an adjoining property. Here, other than having an armed guard, or not armed, but just a 24-hour security guard, what were they supposed to, would be an unreasonable standard, what are they supposed to do? There's only one means of egress and 2 locked doors to get in there, and keys are only given to the construction workers.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Dan Montagna from Gardner and Bloom for Appellant S&S Plumbing Corp. I'm here to, in some sense, echo.
Yes, the irony is that both of you, both the earlier counsel and you, you're saying foreseeability, and then Syncom, whose employee let the person in, is out of the case.
Exactly right, Your Honor.
I didn't have anything to do with it, but the guy who has an employee let the person in, he's out of the case. So why are we still in the case?
Absolutely right, Your Honor. And I really
So you guys, your clients were contracted to remove the radiators.
Correct. Yes. And as Your Honor alluded to, the fact that the Syncom was let out, I think really goes back to the fact that the lower court really didn't analyze this under the proper standard, which was plaintiff was undoubtedly a trespasser, right? And so when you have a case where there's indisputable that the plaintiff is a trespasser, you have to look at 2 issues when you're looking at foreseeability. First, has a trespass of this kind ever happened before? And I mean, we can easily dispel with that this was the first time that anything like this had ever happened at this property. And then the other issue is accessibility, right? Were reasonable steps taken to prevent this type of trespass? And as co-appellant alluded to, there was multiple locks that had to be opened. I would direct the court to the case Philip v. Deutsche Bank, which is a Southern District case and affirmed by the Second Circuit, with facts that are very similar to the case at Barr, where an individual was able to get access to an apartment against the wishes and without permission of the owner. In that case, the apartment was also locked. Just in this case, there was a window, at least one that was boarded up, and the apartment was frequently checked for trespassers, just as this one was. And again, summary judgment was granted to the defendants in that case, and we believe it should have been granted to the defendants in this case.
So S&S had finished your work months prior to the incident, right?
At least weeks, yes.
Weeks prior. So the issue was an Espinal issue as to you, right?
That we didn't launch the force of harm. Yes, Your Honor. In those intervening weeks, there was testimony that the plumbing had been tampered with. Plaintiff himself testified that he tampered with the plumbing, as well as Mr. Hernandez with the valve prior to the incident here. So for that reason, we do believe there is an issue that we shouldn't be held to have launched the force of harm when there were weeks in the interim that there's actual evidence that other people did manipulate the valve at issue.
Anything? Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. My name is James Ford. I represent the plaintiff in this case, and we are obviously opposing the appeals that have been filed by Alma and by S&S. I just really need to clarify something at the outset. The court below did not make any finding that Mr. Hernandez acted outside the scope of his employment. That was not a finding of the court below. Syncom was let out of the case only on Espinal theories, that the court held that that Syncom did not launch a force or instrument of harm.
Well, is there any issue of fact that he had permission to let him into the apartment?
Sure, yeah. I mean, Mr. Hernandez, if you go to the record, Mr. Hernandez was asked, he was asked about his use of the keys. He was allowed to use the keys whenever he wanted. That appears on the record page 465 and 564. He was specifically asked if his boss from Syncom ever specifically told him that he was not allowed to bring anybody into the premises, and he said no.
So did he testify that he thought he was allowed to bring someone in and let them stay overnight?
After the fact, after the man got badly burned and almost killed, and after the defendants obviously got sued and was concerned about what had happened, yeah, he was expressing, saying that he figured his boss would be mad at him, but not prior. Prior to
I
that,
thought he testified that his boss specifically told him that he wasn't to bring, I'm sorry.
No.
His boss never told him that he could bring friends to the apartment after work hours. However, he did not believe that he was allowed to do so.
his subjective belief, yes, but as far as, if you go to page 564 of the record, he was asked whether his boss or anybody from Alma, from the building, ever told him that you're prohibited from using the keys like that, and he said no.
Did he testify that he's done this, that this was the only time, or that he'd done this in prior occasions too, that let other people into the apartment?
Oh, no, I think this was probably the first time this
It
happened.
was the first time. It was
Yes.
a doozy, but it was the first time, right?
It was.
Okay.
And, you know, it was a humanitarian thing that he
I'm
did.
not questioning, I'm just talking, we're talking about foreseeability. I mean,
And
when you
again,
get into the
was it unusual? Was it something that he felt that obviously in light of what happened, the man being burned over 80% of his body, obviously he's going to express
Foreseeable that
concern.
he would do this?
I'm sorry?
Was it foreseeable that he would do this, that he would allow, as a construction worker, that he'd allow someone in the apartment to sleep there overnight while it was a construction site? Was that foreseeable?
Well, an Alma employee was asked that very question on record page 1370 and 71 at length, and he was asked, was it foreseeable that somebody from Syncom might let in a non-construction worker or non-tenant? And the witness said yes.
During non-work hours on Thanksgiving Eve?
That wasn't what he was asked. That
So
wasn't
what
he was
about the
asked.
testimony that he said, you're talking about Cruz, right? It was Cruz, the property manager said it was his understanding that Simcom could not let somebody that is not in the construction group inside the apartment because it is a controlled environment, it is a construction site. So the property manager didn't think that he testified, you can't do that. It was, no.
But he
So
also.
where is it that you're saying that he said that you could? I'm reading the testimony on 1370.
1370 to
1368,
71.
1369, 1370.
On to 71,
Yeah.
where he was asked whether it was foreseeable that they would let a non-construction worker or non-tenant into the premises, and he said yes.
Into the premises generally at some point. But when he was specifically asked that whether or not it was, you could not let someone that is not in the construction group inside the apartment, not generally onto the premises, inside the apartment.
Well-
And did he not testify? I mean,
Yes,
I'm looking at the
but-
testimony right
but
now.
the-
That's
the-
what he said.
When the questioning about the premises was the only part that was under construction was that one apartment. That was the only place that was under construction.
Did he not testify? Yes. All right. Okay.
But counsel, you don't draw a distinction, and you do not believe that there's a distinction between work hours and non-work hours, and not only that, but non-work hours when it's Thanksgiving Eve?
No, I don't think it is. If you first of all, I think, Your Honor, it's important to realize that Alma, SNS, and Syncom, these are all three interrelated parties. If you're the owner of the building, Syncom was formed, and basically the only one they did work for was Alma. And SNS was actually also a company that was set up by the building. So if you're going to hand over keys to the front door and to the apartment that's under construction to this entity, and he was told, I mean, Mr. Hernandez did say that he could use the keys anytime he wanted. That's in the record. He was not given any specific instructions not to allow
But
somebody, and
Hernandez
he could have been bringing his kid to work. Well,
Hopefully, he wouldn't have left them there overnight by themselves.
yeah, and, you know, he's a construction worker, so I'm really not, okay, thank you.
Good afternoon. May it please the court. Patrick Lawless for the defendant respondent Syncom. Mr. Hernandez clearly testified that he was not permitted to allow people into the apartment after work hours.
He said that he thought that his supervisor, Mr. Rahim, would be mad if he did so, but he testified that Mr. Rahim never specifically told him.
He said Mr. Rahim never specifically told him. He said that Mr. Rahim would be mad if he did, and he also said he had an understanding that he was not supposed to do it and the keys were for work purposes only. And on top of that, the plaintiff himself testified, page 298 of the record, the plaintiff knew he wasn't supposed to be there. So there was.
But he said that Mr. Hernandez invited him.
He said Mr. Hernandez invited him, but he also said, I knew I wasn't supposed to be there as well. So I think it's pretty clear, and it wasn't refuted below, that that Mr. Hernandez was acting outside the scope of his employment.
And Mr. Hernandez said that it was his understanding that he couldn't bring anyone into the apartment.
Exactly.
He never said, sure, I can use the keys anytime and bring someone into the apartment afterwards, right?
No.
He testified, it was my understanding, I think it's page 508, that I was not permitted to bring someone into the apartment after hours.
Exactly. That was his testimony. With respect to the Espinal argument, it's been argued in the briefs. Plaintiff didn't address it on his argument, but in any event, it's clear that the plaintiff wasn't a party to the agreement between Syncom and Alma, and that none of the Espinal exceptions apply to this case.
Who boarded the windows? Do we know?
We don't know. The unrefuted testimony is that Syncom did not board the windows. There's nothing in the record to refute that. Plaintiff makes this argument, and it's quite hard to understand, that Syncom was acting as the GC, but the testimony in the record shows that Alma was the one who was in charge of hiring workers and coordinating the work, that Syncom was just one of the people hired to do that. Syncom had nothing to do with the radiator, and even if Syncom knew there was an issue with the radiator, at most that's a refusal to become a force of good. That doesn't launch an instrument of harm. Thank you.
Alma, you want to?
Just to address one issue, and actually I had addressed it before. Counsel references Mr. Cruz's testimony, not that it's dispositive on the issue, but that he said it was foreseeable. Again, that the part of the record is R1370. The question was, is it foreseeable? And then the question was changed. It can happen that workers could be let in. And to that is when he said yes. He didn't say yes to the way it reads, it did not say yes to the foreseeability, just to the it can happen.
And then he also said nobody's supposed to be there other than construction guys.
Right. There was extensive other testimony, but that's the testimony that is being cited for somehow to show that it was foreseen by my client.
Thank you.
Thank you, Your Honors. And I'd just like to highlight the fact that, it's not Mr. Hernandez's permission that the plaintiff would have needed to be in the apartment. It's the permission of the owner. And it's very clear that he did not have the permission of the owner.
And he stated that he knew, the plaintiff stated that he knew he was not supposed to be in the apartment.
Correct. Thank you, Your Honors.
Thank
you. Just quickly, Your Honor, as far as the, even if the plaintiff was a trespasser, there are still the cases that we've cited, and in particular the two Court of Appeals cases that were in from 1993
Yeah,
to
I was
2014.
thinking about that, and I was going over reading those cases where the individual was a trespasser. But in this particular case, how do you address the fact that we have double locks? We have a lock for the main entry, we have a lock for the apartment itself, and we have no indications or no record, no complaints, nothing as to other individuals who were, for want of a better word, squatting in the apartment or using that apartment.
Exactly. He was invited in by someone with a set of keys. He didn't break into the place, which makes him less of a trespasser than somebody who just decides during a drunken party that they're going to open a window, go out on a roof, and fall off the end of the roof. He was invited in, at least with someone with colorable authority, to let him into the building on a cold night before Thanksgiving. So, I mean, the cases are there are some pretty wild fact patterns out there where people have been trespassers, they have been someplace where they're not supposed to be, and the question still remains under Basso versus Miller, reasonable care under the circumstances based upon all of the facts, which is why it wasn't amenable to summary judgment. The one issue that I also wanted to bring up with regard to SYNCOM, our cross appeal, is that SYNCOM has abandoned Espinal arguments on appeal. They did not raise that or make that a part of their appeal at all. They did, in fact, they were aware that the boarded up window was there, and SYNCOM employees actually had to loosen that window. During the course of doing the construction work, Mr. Rahim testified that his workers had to loosen that window to increase ventilation. So they knew that fire escape window was boarded up, and also Mr. Hernandez, the last thing he did their employee did before he left was he closed all the windows, even though he knew that the apartment was filling up with steam, which also was launching an instrument in form of harm. So they were fully aware of both the leaking steam, which is why they should not have been let out of the case by the court below. And the other two defendants were properly kept in to the case based on questions of fact.
Thank you. Thank
Thank
you
you.
all. Bovis Lend-Lease versus Lower Manhattan.
Good afternoon, and may it please the court. I'm Greg Silbert for Bovis. This court already granted summary judgment in favor of Bovis.
So this is now Bovis 4.
Yes, Your Honor,
Okay.
if you're counting.
I was on Bovis 3.
I know you were.
I don't know who was on 1 and 2. Hopefully no one will be on 5.
Hopefully there won't be a 5, Your Honor. What this court did in Bovis 3, as you know, is remit for a trial on damages. And so if there is any factual dispute at all about those damages, then that trial has to go forward. We have shown that we are entitled to try damages for both fire damage repair costs and excess demolition costs. I will start with fire damage repair costs. Bovis incurred about $7.1 million in damages to repair damages from the fire that resulted directly from Galt's negligence. And Bovis could not recover those costs from the owner, LMDC.
What's your response that it's not covered by the broad language of the settlement?
Of the release, Your Honor, the language of
Settlement
the
and
release. So the most important part of the release is the language that Arch never quotes, and that is at page 526 of the release, and it says, this paragraph, this release paragraph, does not apply to any rights or obligations that are expressly reserved in that settlement. And then on the preceding page, which is 525 of the record, it says, claims against Arch, which were already pending at the time the release was signed, are expressly reserved and not covered by the settlement. So by its express
When
terms...
you settled that case, when you had entered into that settlement, Arch didn't know about it. You didn't get Arch's consent, did you?
That's right, and
They had no idea you were doing this.
That's right, but the
And then at the end of the day, you're trying to tie in the damages to them, but they didn't have a chance to even express.
Important point, Your Honor. That's exactly what we're not doing. Okay, so
Well, that's what you're saying you're not doing, but they beg to differ.
Well, let me show you exactly why we're not doing it. Okay, starting with fire damage repair costs, we incurred $7.1 million. Arch says we sought that same money from LMDC. That's why Arch says it was settled. But the record is clear that Arch is pointing to different costs for different work by a different subcontractor incurred at a different time, okay? The costs that Arch is referring to are at pages 444 of the record. It is for about $6.4 million. We're claiming $7.1 million, different amount. The work that Arch is talking about was incurred by a subcontractor called LVI, and you see that at the bottom of the chart.
So may I ask you, counsel, are they abatement costs that you are seeking?
No, we are not seeking abatement costs.
What are they? What specifically are the costs that you incurred?
This first category of costs is for fire damage repair.
That's abating the fire, right?
No, it's not. It's not abatement, Your Honor.
How could it not be abatement? You can call it what you want, but it's the abatement costs for the fire.
You know what, Your Honor, don't take my word for it, take Arch's, and you see Arch's statement of this at 1145 of the record in footnote 8. It's a prior brief to this appeal, and Arch says there, it is easy to distinguish abatement costs from fire costs because the fire work was done by Gramercy and the abatement work was done by LVI. We are seeking the fire work done by Gramercy. Arch is pointing to abatement costs by LVI.
And what are you saying about those costs? They're not covered in the settlement agreement?
They absolutely were not covered in the settlement agreement.
And they're not covered, they're not abatement.
They're absolutely, Arch does not dispute.
I'm trying to still understand that. They're not covered in the settlement agreement, but had you given notice to Arch that you were doing this with the LMDC, that they may have had input in there because this is all tied into to rebuilding after the 9/11 tragedy, right?
Arch would not have had input into those costs, Your Honor, because we only ever could and did seek those costs from Arch. We never sought them from LMDC. So it's true that Arch had to indemnify us before the breach of contract for damages that we incurred to LMDC.
Yeah, you ended up paying LMDC $40 million, right?
That's right, Your Honor.
Instead of you sued them, they countersued you.
They countersued, and we could not recover that from Arch. That's the result of the breach. But that has nothing to do with the damages that we incurred that were never part of the LMDC suit that we could only recover and only ever sought.
Let me back up a little bit.
Yes.
Your relationship with Arch was a performance bond, right?
Correct.
They issued 2 performance bonds because Gatlin, I forget the... Galt was the contractor, right?
Correct.
For the 2 performance bonds.
Right.
So how is it now that the fire that resulted from Galt's, negligence or whatever, alleged negligence, whatever, how is that fire damage something that wasn't covered in something recoverable when it's a performance bond that we're talking about, not an insurance policy? Am I missing something?
Absolutely, it is recoverable. That's exactly the point, Your Honor. So if Galt engages in misconduct that increases our costs, we can't recover that from the owner, LMDC, because LMDC is not responsible for Galt's misconduct, but Arch, who is the surety, is responsible for Galt's misconduct, and that's why we only ever sought those costs from Arch, not LMDC. Also, the costs that Arch is referring to were incurred at a different time. All of the 6.4 or 6.5 million that Arch refers to, that was incurred all in 2008, from January 2008 to April 2008. The fire costs that we are referring to, they were all incurred in 2007. You see that clearly at page 907 of the record. Now, there's another category of costs, excess demolition. Exact same story. Arch is pointing you to different costs for different work from a different time. Two buckets there. First bucket is $13.2 million in direct costs for additional demolition. Arch says, well, that's the same as $13.9 million in approved change orders. Well, right away you can see 13.2 is not the same as 13.9. And if you look at the breakdown of that $13.9 million that Arch points you to, which you will find at page 298 of the record, you will see that $11.7 million of it is for general conditions costs.
Thank you. You have time in rebuttal.
Thank you, Your Honor.
Good afternoon. Kevin Gary for Respondent, Arch Insurance.
Counsel, I have a question. How, as opposed to the abatement costs, the fire costs, what's the basis for your argument that the fire costs are covered by the LMDC settlement agreement?
Because the costs that Bovis pursued against LMDC included those very same fire
And
costs.
what's the authority, the basis for that argument? Because your
Did
opposing
what was
counsel is arguing to the contrary.
That what was attached to Bovis's expert report against LMDC were Bovis's cost records detailing its expenses, including the fire and demolition costs.
So it sought, and in the other lawsuit, it sought those costs against LMDC, correct?
Absolutely. Those are the cost records that I'm referring to, Your Honor.
Right. So in that action, it said these costs, LMDC owes us these costs, correct?
Correct. They
And then
provided
it signed a settlement agreement that said, I release you from any other claims.
Absolutely.
So, okay.
They ended up paying $40 million to LMDC.
That's exactly the situation, and you are correct when you asked my counsel.
So why is your opposing counsel arguing that these fire costs were not covered in the LMDC settlement agreement? That was
Well,
those were different amounts.
what's interesting is they make that argument, but they do not point to a single piece of paper that demonstrates
I thought he said it was in a different year. I thought he said it was 2007. Can you say something like
No,
that?
the fire took place in 2007, and abatement costs were incurred from the beginning of the job in 2005 until 2009 when they were completed. You know, all
I
of
just
these
want to make
expenses-
sure, triple sure, that $9 million was sought by Bovis from LMDC in the other action.
Absolutely.
And you can tell that because the expert's report in that action shows that number.
Correct,
Broke
and
it
they
down.
had
I
the-
looked at the expert, it's like 4 different sets of
Correct.
costs,
But
right?
what was
Okay.
attached as an exhibit to the expert report were the Bovis cost records detailing each and every expense they incurred. It went on for hundreds of pages.
And that settlement agreement says any claim you could, not just the ones you brought, but anything you could have brought against LMDC.
Correct. And then wraps up with a general release that is to be interpreted as the broadest form of general release cognizable under the law.
I mean, you know, he makes the argument that when I said that you weren't involved in that settlement, is that you weren't told about it. The argument was that you didn't need to be told, but if it was in terms of the fire that was resulting from the contractor that you had the performance bond on, I think you had to be involved in that.
Correct. That pursuant to the companion agreement, which was the settlement between Arch and Bovis, if they wanted our participation, they were required to get our consent. They refused to get that consent, and as a result, this court in 2017 dismissed Bovis's claim in its entirety on the companion agreement. They said it was gone, nothing left.
That companion agreement was the abatement. That was actually the project itself.
That companion agreement became the settlement agreement that governed how the project went forward.
Separate from the fire.
Correct.
Fire costs.
Excuse me?
That didn't cover the fire costs. The fire costs is, your reason why you're saying the fire costs are not recoverable is because of the settlement agreement, not because of the companion agreement.
Correct. It was a result of this court decision that dismissed all of their claims in the entirety, which include the fire claims, as well as the demolition.
And is that your argument on your $9 million claim, that because this court said that you didn't have to pay that $9 million to start with because you didn't get the they didn't, Arch didn't get your, I'm sorry, Bovis didn't get your approval for this, for that settlement, that you were not required to put out anymore.
Correct.
And
That,
that's what this court held.
correct. That in connection with a court decision that this court affirmed in 2016, where the trial court found in 2015 that we did not have a funding obligation to Bovis because Galt's incurred costs had never exceeded the $65 million threshold. So as a result, that has been the law of the case 7 years now. And certainly, you know, our position is that you should just simply affirm the decision below. Thank you very much.
Thank you.
Please look closely at this record before you rule. Without any shadow of doubt, we did not seek those fire damage repair costs from LMDC, nor could we. The costs that Arch is referring to, you find them at page 444. That is $6.4 million in costs incurred by LVI from January 2008 to April 2008. The costs that we are seeking from Arch are $7.1 million in costs that we incurred entirely in 2007. That work was done by a different contractor,
Right,
Gramercy.
that's what I thought. You had made reference to 2007. and you
Exactly
said that
right.
there were separate costs.
Separate costs, separate subcontractors, separate work, separate time period. Look at page 907 of the record. Those are the costs we're seeking. 444 of the record, that's the cost he's referring to, completely different. 321 of the record tells, yes.
Let me just ask you, in that action, your expert said your total costs were $283,730,251, correct?
No, not correct.
No.
No, not correct, Your Honor. That's what Arch says. That is categorically wrong. What we said is the amount we are owed under the contract is $284 million. So if you hire me to paint your fence for $100, you owe me $100 under the contract. That says nothing about my costs. And that is the fundamental mistake that Arch makes. It says that $284 million is costs. It was not. It was the amount that was due under a... This...
If you say the contract says this number, you don't need an expert. You put in an expert, right?
Because, no, unfortunately it's not that simple, Your Honor. Because there were many disputes.
Why would you put in an expert report if the damages were calculable under the contract?
Because there were many fact issues about what damages LMDC had to pay for, but never did we claim against LMDC these damages that we are seeking from Arch, which are fire damage repair costs and excess demolition costs. The record is actually crystal clear on that. And if there is even a dispute, then we get to go to trial.
Okay,
you.
no, okay.
Thank you, Brian. Thank you both.
Thank you.
Goldberg versus Schwartzberg.
Good day, Your Honors. My name is Raymond Schwartzberg. I represent the defendants, appellants, pro se. Allow me to quickly review some chronology. It's a dispute by the plaintiff claiming legal fee referral fees, and it's a lawsuit going back for claims back to 1990. Commenced in 2017.
Why don't you explain why you think the complaint should have been dismissed?
For several reasons. Firstly, the plaintiff, after the year 2000, never performed any substantive legal services, work, or labor. Moreover,
Was your motion to dismiss a motion on the merits?
it was a motion to dismiss, but it was the motion to dismiss that was denied, which is not...
Discovery motion to dismiss, right? It wasn't a motion on the merits of the case.
It was a motion to dismiss not on 30-11.
So we're not analyzing it like a 3211 motion, whether there's merit to the claim. We're analyzing it as a 3126 motion,
It was
right?
a 3126 parentheses 3 motion because the,
So why, using the language of 3126 as opposed to 3211, since that's what you moved on, why were you entitled to a dismissal?
well, I'm perhaps confusing it. 3211 was the motion that was used to dismiss it against the defendant, my daughter, and the defendant, my son-in-law, who were also named in the lawsuit.
But that's not what's before us in this appeal.
No, that's not what's before you.
Okay, so let's focus on the 3126 motion. Why should you have been granted dismissal based on 3126?
Because after 2 years of inactivity following the commencement of the action in 2017 for referral fees going back to before 2007, back to 1990, the case was called on the inactive case calendar call in the Bronx before Justice Simpson because it had been inactive 100% since its commencement, except for our motion under 3211A to dismiss the case against the two relatives. That was an intimidation tactic I respectfully submit to this court. There was no purpose to it. They knew better about it. And there was no response to our demand for a bill of particulars asking what work did you do?
Right, so under 3126, you would have to show that their failure to disclose was willful,
Contumacious.
contumacious, common sense, contumacious, or in bad faith, right? And so was that showing made?
Yes, more so than that even. Before Justice Simpson.
How so?
Before Justice Simpson and Justice Briganti, to whom it was referred that very day on September 9th, the plaintiff was told, provide the bill of particulars within 45 days or move within 90 days to have a protective order so that you don't have to respond to the answers. They did neither. They didn't respond to the bill of particulars demands within 45 days, and when they did, you can look at what they did provide at the record at page 200, where they said, we don't have to answer these questions. We can answer other questions. And the bill of particulars was rejected, and they didn't even respond to discovery, and they said, we didn't have an agreement between the...
But the court then did require them to respond within a specific period of time, and they responded during that period of time.
No, they firstly were late, and then they didn't respond in any measure accurately or correctly answering any one of those demands of the bill of particulars. They answered their own questions. They did not respond to the demand. The court has only to look at the record as to what was asked of the plaintiffs, and you'll see that...
Oh, wait, wasn't there a discovery order? I don't remember what date. Wasn't there a discovery order by the court directing them to respond within a certain period of time? And did they not respond during that period of time?
They did not respond within that period of time. They respond beyond that period of time, and when they did respond, it was absolutely and totally unresponsive. They didn't answer one particular that was requested, and they filled 2 or 3 sheets of paper. You could look at what they wrote, and we served them with a notice of rejection in the record. That's at record 195 to 196. It was shown, the would-be bill of particulars, which was an answer to questions that don't exist here, was at 198 to 201. And when we went back as ordered to the court before Justice Douglas, who was the person who was in charge of the follow-through on the inactive case part calendar, we informed the part, Justice Douglas's part, that they didn't answer the bill of particulars timely or in any measure correctly. They didn't provide the discovery in any measure timely or directly. And what's more, they served a would-be disc months later somewhere around February of 2020, following the December 9th conference.
Thank you. You have time on rebuttal.
I do have to mention that when I reply, I want to have 1 minute to bring out that there was a stay with regard to...
Yes, so you do have time on rebuttal, so you can bring out whatever you want to bring out during that rebuttal.
I will, thank you. I wanted to alert you that there's a third proceeding regarding a stay.
So this is cutting into your rebuttal time. I'm alerting you to that, okay?
Good afternoon, Your Honors. Darren Epstein on behalf of Marvin Goldberg, PC, and Marvin Goldberg. Your Honors, with regards to this matter, I would submit on the papers that we have provided. I think that it's very substantive with regards to what we did do, that we did provide the discovery at the time, that the defendants have not provided any discovery at all with regards to that, which forced our motion to compel. And with regards to their motion, which the court decided, they looked at all of the facts in the case, they looked at the discovery, and they made a determination that sufficient discovery was provided to them. Thank you.
The court below did not rule that the bill of particulars was adequate.
Counsel, why don't you talk about the stay, since that's what you want to talk about?
I'll talk about the...
If that's what you want to talk about, now's your time to talk about it.
Yes, there's a second appeal here, and there was a third proceeding as well, which doesn't seem to be before the court somehow. We responded on the 24th of April. That was the stay of Justice Mendez, and actually, plaintiff responded on the 24th. We responded on the 28th. There is a second appeal that was before the lower court, which said we said that since the motion to dismiss being based on a lack of an affidavit of merit of the plaintiff as to the representation that there were services or labor or work performed by which they have a right under the law. All the cases that are involved, the Morse case, there are about 10 or 12 cases.
So, counsel, let me ask you, with respect to your cross appeal from the order granting the conditional order of preclusion, right? You didn't oppose that below, did you?
Well, what I did do, I asked the court to adjourn that because the material being asked for was palpably improper. Not only was it palpably...
No, but I mean, so what? Did you put in opposition to that motion?
Yes, to the extent that we said that the material requested was palpably improper.
You put in a piece of paper that said that? You put in an affidavit in opposition?
Yeah, well, in the record, you will find...
I didn't see any opposition to that motion.
When did you submit that opposition?
It was part of the in support of our motion to dismiss for the failure of the defendant to have either an affidavit of merit to vacate its failure to obey the court orders, and we asked the court to adjourn. But the court said, the court concluded without a basis that it was willful. It was not willful. It was a representation that the court should adjourn that discovery order, application for an order, pending the decision.
Thank you. We'll take a look and we'll find it. Thank you very much.
I want to just say this, that I'm not sure...
Thank you both. We really appreciate it. Have a great day. Take care.
Thank you.
Thank you. Tahari versus Narcus.
Good afternoon. May it please the court. My name is Stephen Wagner. I represent the appellant Shlomo Narcus, also known as Shelly Narcus. We ask this court to reverse the lower court's decision on a number of grounds, but I will only concentrate on a few. The first question is whether the the agreement that was entered into in 2005, that's the date, is a tolling agreement or is as Justice Bark found, is an extension of the loan. The problem with Justice Bark's decision is that neither them nor us ever said that it was an extension of a loan. It was a tolling agreement, and it's all over the record.
Where in the record does it state that it was a tolling agreement?
Let's go first. In the argument that was before Justice Bark,
Counsel, what about the language, it will be enforced after 10 years? What does that mean?
is enforced after 10 years.
No, it says it will be enforced after 10 years. So how are we to construe that language, will be enforced after 10 years?
The agreement says, Your Honor, the document will be enforced after 10 years.
So how are we to construe that language?
That is a tolling agreement, that they cannot sue.
Why couldn't that equally be construed to mean that there will be no collection on this debt for 10 years?
Because they,
The term of the loan is extended by 10 years.
10 years.
which is what Justice Bark had concluded.
Why wouldn't that be a reasonable reading of this language, which is the language in the agreement?
Because it then would render Section 2, Paragraph 2, completely useless and redundant. Paragraph 2 says, Shelley hereby undertakes to repay his debt to Ellie whenever he or his beneficiaries have possession of said amount, in part or in full, until the full repayment of the amount, principal and interest, which means that that's the term of the loan.
No. Have you ever seen a no prepayment penalty in a loan? That says, I can pay it off as fast as I can, but that doesn't mean that the term of the loan is different.
The term of the loan is when I pay it back.
Right,
I pay
which
it
could
back.
be, if I pay it back before the end of the term, that becomes the term, but it doesn't mean that I don't have all the time possible
Doesn't
to
mean you
pay
have
it
30
back.
years.
Yes.
But-
You're saying that clause means you can not pay it back for 40 years. But
That
wouldn't
clause-
that equally obviate the other part of the agreement, which has a 10-year, that after 10 years, they can collect it?
After 10 years, they can sue for it. That's the argument.
That's
that
the
after,
same as that they can collect on it after 10 years.
Yeah,
There's
well-
no difference between those two.
That, Your Honor, is where I disagree. That the
Well,
You're saying they have to wait 10 years, and then if they don't receive the monies within the 10 years, then they can sue?
they can sue, they cannot sue for 10 years.
But when they
After
sue
10
after 10 years, you still don't have to, your defense is that I don't have to pay it for 30 more years because I don't have the money, and that would be a viable defense?
Well, this is what the agreement says. I'm reading the agreement.
so wouldn't
so-
it be equally, I mean, maybe both, it could be either one or the other interpretations,
Well,
right?
it could be, but neither party advanced that theory, Your Honor. The theory that was advanced was, and I'm quoting now from page A46, and this is from the plaintiff side, I mean that 2007 written agreement that told the statute was entered into for their benefit. The position in the complaint, the position in the motion to dismiss has always been this is a tolling agreement. We said, and I think it's clear, that if it is a tolling agreement, it's unenforceable because it was entered into in 2005 and the debt didn't become due until 2006. That's a straight statute. So the only question is it a tolling agreement or not? The positions of both parties was it was a tolling agreement. This court has said that the court cannot.
How can we decide as a matter of law whether or not that's a tolling agreement? It's very unusual language, you must admit. So how, as a matter of law, can we say it's unambiguous and it is a tolling agreement?
Because both parties have taken that position. Both parties, without dispute, have taken the position that it is a tolling agreement, as I just read, and there are countless, I shouldn't say countless, there are a bunch of references in the complaint and in the motion, the opposition to the motion to dismiss, which clearly indicate that both parties said it was a tolling agreement. This court in the Bertrand case said that you cannot, the court cannot impose a interpretation of a contract that was not advanced by either side. That's on the statute of limitations. The other.
You have time on rebuttal.
Thank you, Your Honor.
Good afternoon. May it please the court. Marie Matthews for respondent Ellie Tahari. And
So, you know, I have to ask you, did you not argue below that agreement extended the term of the loan?
Of course
or that
we
it
did.
was just a toll?
Of course we did, Your Honor. We said that it had the effect of tolling the statute of limitations because it
Tolling the statute of limitations because the loan was extended for 10 years.
Exactly.
Okay, that's different than saying the loan is due today, but I won't sue you for 10 years.
Right. The written agreement that was entered into in 2007 modified the original terms of the 2005 agreement by giving Mr. Narkis 10 additional years
At least
to
that's
pay.
your view of it, not theirs, but maybe, right, okay.
Yes,
Okay.
understood.
I just wanted to make sure that I wasn't mistaken. That
Yes. We allege very clearly in the complaint at paragraph 44, which is at Appendix A, as stated in writing in the loan agreement, Narkis agreed to repay the debt, principal and interest, within 10 years. And we said multiple times at the hearing, at the trial court level, that it had the effect of tolling the statute of limitations. That doesn't make it a tolling agreement under the general obligations law. And I will address what other questions your honors have about the statute of limitations.
Is there any doubt that the money was given?
Meaning transferred from?
Transferred, right.
There's no
one
doubt.
disputes
It is not denied that.
And
Mr.
there's
Narkis-
this document. Does either party dispute that this is a contract about that
No, Your Honor.
transfer? So then why do you need unjust enrichment? Why do you need all the quasi-contract claims if both parties agree that the money was transferred and that this contract governs the terms of the transfer?
Because Mr. Narkis is claiming that the 2000 written agreement where he affirmed the debt is unenforceable. To the extent the court rules it is unenforceable, we require those other claims in the alternative. Of course, we're not trying to recover $9 million twice.
But essentially, if that's unenforceable, then the statute of limitations would doom you in because you can't.
On
right?
on the contract-based claims, but on the fraud claims,
On the fraud claims, right, different thing. But all the contract and quasi-contract claims are doomed.
Yes.
If the contract is unenforceable, then all those claims are doomed.
All the contract-based
Yes.
claims, yes.
Yeah, okay.
Thank you.
If I may, very quickly, I would refer the court to page 14 of our initial brief. The language is, Tahari agreed, this is from the complaint, Tahari agreed not to sue Narkis to recover the debt for 10 years. Due to Narkis's written promises, Tahari refrained from filing an action to recover the loan for 10 years. And I have a list of those. Those are classic tolling agreement language. To go to the fraud count, Your Honor, it should be dismissed. There is no question that in 2006, Mr. Tahari retained counsel who accused Narkis of fraud.
But there's a difference between a general allegation of fraud versus the later allegation of fraud has to do with the reason for giving the loan, which is part of the plea agreement. It wasn't until, according to this record, until 2019 that they would have had any potential notice about that.
But that's not true, Your Honor, because they say that our clients believe that they have been defrauded as a result of the foregoing. Absent the immediate resolution of this matter, Tahari will be left with no alternative, etc. Then a follow-up letter said that we don't owe you anything. That's what the response to these letters was. We don't owe you anything.
The basis of the alleged fraud is I wouldn't have lent you any money if it wasn't for your telling me, your misrepresentation was that I needed the money so I could stay out of jail. That's the misrepresentation. Or the alleged, maybe I don't know if it happened or not, I'm just saying that's what they're alleging. The first time you allege that you did, the first time they are saying that they knew that you didn't need the money to stay out of jail was when you put it in an affidavit in 2019. So, and you didn't come back and say, no, here's a document in 2006 where I told them I don't need this money to go out of jail. So at a pre-answer motion to dismiss, that is a good toll. That is a good, what do you call it?
Fraud.
fraud in
Claim for fraud.
Yeah, in terms of the statute of limitations. Oh, inquiry notice, I'm sorry, there it goes.
Inquiry notice.
Inquiry notice would not have happened until 2019.
And Your Honor, they say in this letter,
Which letter?
the letter at 256 in the record,
What's the date of the letter?
the letter 2006, Your Honor.
Okay.
Individuals are close family members who he believed, apparently incorrectly, he was helping out of a crisis. So in
But he
2000,
didn't know for sure until the defendant specifically averred in that affidavit in July 2019 that he didn't need the money for the plea bargain, and that in fact the monies had been sitting in his wife's or ex-wife's bank account or whatever for X amount of time and was never used.
but at that point, Your Honor, he was certainly on inquiry notice when he says apparently incorrect.
Apparently, but now we know for sure because the defendant is now specifically stating, no, I didn't need the money in 2005, and when I notified you in 2005, and when my son notified you in 2005 that I needed the money to get out of jail, it wasn't true.
I mean, don't forget, this is a pre-answer motion to dismiss. Maybe you will have a smoking gun document that will show, or someone will testify. Yes, your client will testify. I told him in 2006. And it's not that you won or lost the claim. It's just that at this point, we can't make that determination.
Thank you both.
Thank you, Your Honor.
Martin v. Gelco Corporation, Justice Oing is recused.
Good afternoon, Your Honors, and may it please the Court. Matthew Corcoran for the defendant appellants. I'm hoping we can close the day out with an easy one, Your Honors. We are arguing that the summary judgment decision in favor of plaintiff need be reversed because of questions of fact given the party testimony in this matter. This is a pedestrian knockdown in which my client was driving, making a left turn from East 30th Street in the Bronx onto Bronxwood Avenue.
230th Street, making a left onto Bronxwood.
Correct, Your Honor. Which is an unmarked crosswalk area. He stops at the stop sign at the intersection of 230th, looks to his left, observes two pedestrians on opposite corners of Bronxwood Avenue, waits for one to cross to the other, notices everything is clear, goes to make his left turn.
Waits to one to cross with the other. I thought the two were walking hand in hand.
These are two different pedestrians, Your Honor. He observes two young, he believes, teenagers on opposite corners, waits for one to cross to the other. He then goes to make his left turn, and when he testifies, he is approximately 97% done with his turn, and the front of his vehicle is past the area marked for parking on the side of Bronxwood Avenue. He suddenly sees the plaintiff, Martin, to the passenger side of his vehicle, slam his hand on the hood of the vehicle.
And that's different than what's in the police report where he says he didn't see them until after impact.
I disagree with you, Your Honor. He says that he doesn't see them until the moment of impact, which is consistent with his testimony, that he sees them suddenly on the side of his car.
How do we account, therefore, for the damage to the driver's side of the vehicle, to the front of the driver's side of the vehicle?
Well, our client says that there was no damage to his vehicle, and he says that he never discussed any damage to his vehicle.
I thought the police report indicated that there was damage to the front of
there is a damage
to the driver's side.
There is a damage code in the police report, but there's no evidence that, one, that damage occurred as a result of this accident. It could have been pre-existing. But my client also testifies there was no damage to his vehicle. And also, I understand the police report is certified, but we don't know if that was based on the police officer's personal observations or based on the conversations that he had with the plaintiffs based on their version of events. So I would argue that that police accident code is not necessarily admissible and indicative for summary judgment for the plaintiff.
So your client states that the two plaintiffs, that the older plaintiff bangs on the passenger side of the vehicle and then immediately drops to the ground and then pulls the teenager to the ground after him, right?
That is our client's testimony, Your Honor.
So now when the police come on the scene, why doesn't he tell the police what occurred? That these individuals were, faking this accident. He doesn't say anything to them, and as my colleague mentioned, he only talks about, having not. He mentions that he did not see the two individuals, right?
Well, he does testify that he did tell the police that. Why it's not in the police report?
That he told the police that this was a fake accident?
That he told the police the gentleman banged his hand on the hood. And
But does he say that it was a fake accident, that they immediately dropped to the ground, and that Martin, I think it was Martin.
Martin, yes, Your
Yeah,
Honor.
that Mr. Martin immediately dropped to the ground, and then he drags AD down with him?
He doesn't go so far as to testify that it was a fake accident, but he does testify
No.
that the
Does
plaintiff
he tell the
initiated
police
contact.
officers this at the scene? I mean, again, common sense would be that if this effect, I know the common sense today.
How the
But,
tables have
just as
turned.
a driver, you know, we all drive, and most of us drive in the city. So that if this occurred, when the police came on the scene, I would be immediately yelling at the police officers that this is what occurred.
Well, Your Honor, I'd like to raise 2 points about that. One, he does testify that he says the person slammed his hand on the hood. And I do want to point out the case of Concepcion versus City of New York you can find on page 4 of my reply brief, which states that later affidavits or testimony that does not directly contradict the police report cannot be claimed to create only a feigned issue of fact. And because there's no information in the police report about the hand contact with the hood, they can't claim that it's only a feigned issue of fact.
But
There is
counsel,
also a
as
writing.
a practical matter, does it, I mean, I also thought that pedestrians always had the right of way. So, I mean, I'm unclear as to, as he's making that left, why is he not ensuring, again, that there's no one coming from either the east or, from either the east or the west?
Well, again, Your Honor, his testimony is that the plaintiff appears suddenly at the side of his car. And you're right, pedestrians normally have the right of way, but there is also VTL section.
No, but that,
Pedestrians
I
are not
mean,
allowed to run into
no
the
matter
road.
what, either your version or his version, he violates the VTL. So they make out their prima facie. The question then becomes, is it the proximate cause of the plaintiff's accident? And your client says nothing about that in the police report. All he says is, didn't see the guy before he was hit. Didn't say he fell down. Didn't say he pulled his son down. He says, I didn't see him before he was hit. Wait, I printed the police report so I could get the exact language. Before he was hit.
Right. You have time on rebuttal. Thank you.
Your Honor.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff respondent.
What do you say about the deposition testimony? I mean, he says, well, okay, but that's not, if that's what you say, then there's a fact issue and we have to go to trial.
No, let me explain to you why it's a feigned factual issue. The lead case in this department is actually one of mine, State of Merjani against DeVito. So 135 AD 3D 616 at 617. And here's what you said, it's directly on point. It is axiomatic that statements made by a party in an affidavit, a police report, or a deposition that are not denied by the party constitute an admission, and that later conflicting statements containing different versions of facts are insufficient to defeat summary judgment, as the latter version presents only a feigned issue of fact.
What about the argument that it's not contradictory, not inconsistent?
It is. Go to page 17. Let's look at the police report, which was what Judge Scarpullo was looking at. First sentence on the line 30. Driver, vehicle 1, states he was making a left onto Bronxwood Avenue from east to 30th Street after making a full stop and seeing intersection was clear. Here's the next sentence. Driver, vehicle 1, further states he did not see pedestrians until he felt collision. You cannot make up a story that you saw the plaintiff feigning an accident before where you say you didn't see them until a collision.
Why is that necessarily contradictory? Because he says a collision, which could mean that the Mr. Martin striking the vehicle, but he just didn't mention the fact that then Martin dropped to the ground and pulled the kid after him.
Because the cases actually really don't say that. If the police report says one thing, you can say, I didn't say it to the police. You could say that the police were mistaken. But not only did he not say that, Judge Weber, on page 196 of the record, he doubles down. And he says, I'm sorry, 195, I had the wrong page. This is on 82 going to 83, it's manuscript. Question, looking at the accident description section of this police report, which we've marked as A0-4, it indicates, quote, driver vehicle 1 states he was making a left onto Bronxwood Avenue from east to 30th Street after making a full stop and seeing intersection was clear. Driver of vehicle 1 further states that he did not see pedestrian until he felt the collision. Again, didn't see him till he felt the collision. So all his testimony about him slapping the right side of the driver thing couldn't have happened because he didn't see him till the collision. Do you see that? Answer yes. Question, is that an accurate recitation of what you stated to the police? Answer yes. So it is absolutely a feigned factual issue. And here's the other point. We cited to a case called Stanford against Ducey, which was reaffirmed in a case decided by this court called Martin against Premium Laundry. Those cases stand for the proposition that if you say you don't see, as a defendant, the plaintiff, you can't speculate that the plaintiff did something which was negligent. The trial court got this one exactly right. And I would only add that in making a left turn, the defendant plainly violated the VTL because he has to see what's there to be seen.
No, I think the question is really proximate.
I agree. I don't disagree with you. But that's what we're doing. And if you look at the Murjani case, it's directly on all fours. If you don't have any more questions for me, I'll sit down. I'll let you talk to my adversary. Thanks for listening to me.
Thank you.
Your Honors, one quick point about the deposition testimony that Respondent's Counsel just brought out. 2 pages after that, on page 198 of the record, he fleshes out that discussion. He's asked by Plaintiff's Counsel how he can get an understanding of my client's version of events, and my client says, the hand and the sound, I saw them at the same time. He goes like this. It was the same moment. My face turned toward him because I'm looking at the left turn as I make it. I saw his hand hit the truck and heard the sound at the same time. It's not inconsistent. It's not inconsistent to say that he didn't see it until the contact.
No, but that has nothing. That says nothing about he pulled the kid down. I didn't hit him. That's the only question, because there's no doubt he violated the VTL by not seeing what there was to be seen. The only question is, did he hit the plaintiff? And he doesn't say I didn't hit the plaintiff. He says I didn't even see the plaintiff until my car hit him. That's inconsistent with I saw the plaintiff pull the guy down, the kid down.
He does testify that the only contact between himself and the plaintiff was Plaintiff Martin's hand on the hood of his car. He testified that was the only contact. And again,
Maybe his hand hit the hood of the car because he hit him.
But
maybe the hand hit the hood of the car as he was falling to the ground because your client hit him.
But,
I mean, I don't know, maybe he clipped him.
well, if that's possible, then you also can't believe plaintiff's version of events because plaintiff says he was in the front of the car. So if that's the case, then clearly there's something wrong here. But the point is, and I would like to cite too, I believe the case is Martinez that Respondent's Counsel brought up from the First Department, a 2020 case. Judge Kern, I believe you were on the bench for that one. That was an affirmation of a finding in favor of a pedestrian plaintiff when there were 2 different versions of the accident. But there's a really important distinction between that case and this one. That was based on a jury verdict. So the court said, we're not willing to go against the weight of the evidence because we don't find that the jury did, and reverse the finder of fact. That's all we're asking for in this case. Whether or not people believe my client's version of events isn't important, with all due respect, this bench. It's up to the jury as to whether they believe my client's version of events.
Thank you,
Your Honors.
Thank you both.
You know,
I'll do it. I know. All right, have a good night. Yeah, unfortunately.